मरते हैं आरज़ू में मरने की, मौत आती है पर नहीं आती. This couplet by Mirza Ghalib speaks of a painful paradox, longing for death that never quite arrives. In 2011, these lines were once recited in a courtroom while deciding the euthanasia case of Aruna Shanbag. Now, more than a decade later, the Supreme Court has returned to the same difficult question in the case of Harish Rana, a 31-year-old man who has been in a vegetative state for over 12 years. This time, the judgment opens with the words by Henry Ward Beecher. God asks no man whether he will accept life. That is not the choice. You must take it. The only choice is how. And then the court turns to William Shakespeare, the famous dilemma from Hamlet, to be or not to be. But this time, the words are not a literary reflection. They frame a constitutional question, the liberty to die with dignity. Harish had suffered severe brain injuries after falling from the 4th floor of his paying guest accommodation in 2013. Doctors at AIIMS Delhi said there is no chance of recovery, and on Wednesday, March 11, the Supreme Court allowed his parents to withdraw the feeding tube that had been keeping him alive. He will now be moved to palliative care, where treatment will be slowly withdrawn under medical supervision. This ruling is very important. Back in 2018, the Supreme Court had said that the right to life under Article 21 also includes the right to die with dignity. But in the 8 years since that judgment, this right had never been used in practice. So what exactly did the court decide in Harish's case? First, it said that a peg feeding tube, which sends liquid nutrition directly into the stomach, is medical treatment, not ordinary feeding. So removing it is not seen as killing a patient. It is stopping treatment that no longer helps. That's passive euthanasia. But how does the law decide whether treatment should be withdrawn? Courts apply the best interest test, weighing the benefit of continuing treatment against the burden of suffering and medical care that no longer can help. They also try to consider what the patient would have wanted. In Harish's case, the court noted he had been an active young man who loved football and the gym. The key question has also shifted from is it right to let the patient die to is it right to keep the treatment going. The law also has safeguards. Doctors must confirm that the patient's condition cannot improve. 2 medical boards must review the case and the family must give written consent. But the judgment also shows a bigger problem. India still has no law passed by Parliament on euthanasia. For now, the families must rely on court rulings and a long legal process to make such decisions. The law can decide what is legal. But when the question is about life, suffering, and dignity, even the courts sometimes borrow the words of Pull.